Thank you. Please be seated. Good morning. This is the time set for oral argument in our cause number CV14-0250. Is it Anzuris? Anzuris versus La Canasta Mexican Food Products. Counsel, we are recording today's proceedings, so when you step to the podium, please identify yourself and your client. Each side will have 20 minutes for argument, and Mr. Erickson, as the appellant, you are responsible for watching the clock and reserving any time for rebuttal that you might desire. We have read the briefs, and we have conferenced the case prior to argument. So with those preliminaries, Mr. Erickson, you may proceed.
Thank you, and good morning. May it please the Court. My name is Doug Erickson. I represent the plaintiff and the appellant in this case, Chris Anzuris. I would like to try to reserve 5 minutes for rebuttal. I will watch the clock, but that's my intention at this point. At its core, this appeal requires, I think, a relatively simple analysis. And with respect to the primary claim on appeal, it boils down to a review and an evaluation of the complaint and the minute entry through which the trial judge in this case dismissed all of the claims. The three primary questions for this court are, one, were claims for statutory wrongful termination, defamation, and intentional infliction of emotional distress sufficiently pled to survive a Rule 12b6 motion? Two, was it an abuse of discretion for the trial court to deny plaintiff leave to amend if any of those three theories were not pled so as to state a claim? And three, was it appropriate for the defendant to ignore all discovery served by plaintiff in this case? Now, the facts, as they are alleged, without the benefit of any discovery, have been pled succinctly and briefly and concisely. They're found in just 16 paragraphs of this complaint. And I suspect the court is familiar with those facts, so I'm not going to review them at this point, except that I will discuss them as I go through my argument with respect.
Counsel,
yes?
You're not arguing that the discovery was essential to the overcoming of the 12b6 dismissal?
Well, the discovery, what we did with the discovery was we focused on three primary topics. We had three primary objectives with respect to the discovery that was served. One, we were seeking to learn the terms of the contract because my client believed that he had a written contract, but he did not have a copy of it. That's why we sought the personnel file. So with respect to overcoming the motion on the breach of contract claim, for example, yes, I think the discovery was important.
So you needed, you needed to be able to rely on matters aside and apart from the contents of the complaint in order to defeat a 12b6 motion?
Well, with respect to the breach of contract claim, for example, the law is pretty clear. Unless there is a written contract, then you have to rely on the statute. Although my client believed there was a written contract, he didn't have a copy. I didn't know what the terms were, and I couldn't plead it. And that's why we sought that through the personnel file as one of the topics through discovery. And before I forget, the other two things that we were focused on were getting communications from La Canasta, the employer, to third parties to support our defamation claim. And we're also trying to beef up the allegations concerning the undocumented workers.
As long as we're talking about the discovery issue, I have a couple of concerns with whether that's even properly before us. As I understand the record, there is not a ruling granting or denying your motion. So, A, what do we have to review? And B, is Ms. Manolio's answering brief statement correct that your notice of appeal didn't identify, well, there is no ruling. So how is that issue properly before us? We typically have a special action brought if there was some discovery issue, a ruling, but here we don't even have a ruling.
It is a bit of an odd context to bring that before the court, but there is clearly, you're correct, there is no ruling. The judge does not say, I've considered the discovery motions, clearly he didn't grant it, but he did clearly deny it. You can take that by inference, and those are found in the orders that are on appeal. The discovery motions were fully briefed and fully before him when he decided the motion to dismiss. Whether the trial judge ignored the discovery motion, felt it wasn't important, felt it was moot, in effect, the trial court clearly denied that discovery motion. So I would argue that it is properly before you.
And what about the notice of appeal?
Yeah, conversely, on that same issue, on the allowing an amendment, there's a ruling, but there's no motion.
There's no motion, but, well, I mean, we requested it 3 or 4 times in response to the motion to dismiss.
But and we're kind of jumping all over, but taking that topic for a minute, one of the problems is we don't have a proposed amended complaint, nor, as far as I can tell, does the record tell us what your complaint would have looked like had you been granted leave to amend. So how do we analyze prejudice?
Well, I think with respect to prejudice, I'm not sure that that is a requirement for entertaining the amendment question.
Well, but for purposes of appeal, I mean, if there is some hypothetical error in the trial court, we don't just willy-nilly reverse every case where there's an error without corresponding prejudice. And there's case law, there's even a constitutional provision that says something along the lines that technical defects that occurred absent prejudice don't require reversal. So we do look at prejudice.
Well, what the law requires, as far as I understand it, is that as a general rule, amendments are allowed unless there are certain features of the amendments which would be found, such as undue delay, futility, which apparently is what the trial court here found. So I can discuss the futility argument if you'd like, or I can just go through my argument, and I will get to that point.
As long as you're going to tell us what was in the record that made Judge Gama wrong about futility, I don't care when you address it.
Okay. Well, let me get to that. If not right now, well, I will get to it before I sit down. So, with respect to the primary issue on appeal, that goes to our statutory claim for wrongful termination.
Now, I find myself a little puzzled by a statement you made a bit ago. You need a contract for the common law tort?
In order to allege a breach of contract in the employment context, you need a written contract.
But, I mean, isn't the wagon seller tort, that was the common law tort for wrongful termination, right? And wagon seller said there was no contract, is the way I remember it.
I can't tell you that I've reviewed wagon seller recently enough with that question
I seem to
in
recall
mind.
that when we had this statute, the Employment Protection Act, that there was some question whether we still had the common law tort, and I don't remember if that's been resolved or not, but I don't think either required either a written contract or even a contract with contractual expectation.
Well, I think what the statute says, and maybe this is where we're getting hung up a little bit, I think what the statute says is, there are only 3 circumstances under which a wrongful termination claim may stand, and that includes violation of a written contract. And I apologize, I believe it's
But your allegation is just that it was retaliatory termination in violation of public policy.
in violation of the statute.
Okay.
Correct. We also, I put the breach of contract claim in there because I assumed there was some sort of duty with respect to the plaintiff, the employee, with respect to termination, and firing him for bad cause probably would have violated that contract. But without having the personnel file and the written contract, if there is one, I couldn't very well present that. So and you are correct, Judge Thompson. The primary thrust of the complaint was the statutory wrongful termination claim. The statute very clearly and very simply tells us what's required, and that is ARS 23-1501. And the provisions that we were looking at are found in A3, which states that an employee has a claim for termination of employment only if certain circumstances are met. One is that the employer has terminated the relationship in retaliation for either of the following. 1, refusal by the employee to commit an act or omission that would violate the statutes of this state. And with respect to the complaint, the allegations that fulfill that cause of action are paragraphs 5, 8, 9, 10, 12, 13, and 16. The second basis on which a wrongful termination under the statute may be brought in this instance is where the employee has disclosed in a reasonable manner that he has reason to believe or reasonable belief that the employer is violating statutes of this state. That cause of action, in our opinion, is very plainly pled in the complaint, and that's in paragraphs 5, 8, 11, 12, 13, and 16. If there was any sort of failure to allege a required element, and frankly I don't see that there was, but it's pretty clear to me that an amendment would have cured that. And then we start to look at, if you want to talk about the prejudice to my client in not allowing the amendment, frankly, I think even within the confines of Rule 11, I could have simply pulled out the language of the statute and pled those, with some adjustment, some revision. I could have pled those as facts that applied to this case. Now I think that's pretty much what we did.
Can I interrupt because you're running out of time, and I think the argument you just made is your best argument for a reversal in part in terms of the retaliatory termination claim. But I'm not sure the same can be said for the defamation and intentional infliction claims, nor am I as comfortable with the notion that the record supports us reversing Judge Gama's finding of futility as to those claims.
Well, I'm not sure what the basis for supporting or affirming the decision would be with respect to futility. With respect to the defamation claim, the defendant argued two things. The defendant argued that it was insufficiently pled, in which case I disagree, but I think an amendment clearly could have cured those. I think all we needed to add probably was that the statements made by the employer impugned Mr. Anzur's honesty, reputation. The statements that were made to DES in the context of his unemployment claim.
Well, it can't be that he voluntarily quit. That's not a defamatory statement. So what did you allege that the employer said to DES that was actionable? Well,
what it appears was said was that his firing was the result of willful or negligent misconduct. And that's found in paragraph 15.
That's pretty nebulous. So what is there in the record that would show that you could have amended the defamation claim to state an actionable cause of action, assuming that was insufficient? What's in the record?
Specific to your client.
That's in the record?
Yes.
I would tell you there probably is nothing in the record that would tell you exactly what we could have alleged, because we were not given that opportunity.
But so your client had no knowledge then of specific comments of a defamatory nature that were made, but you could have found some if you'd been allowed to do discovery.
Well, I think we had the information concerning the statements made to DES. What we did not have, the second component of the defamation claim, would have been the statements that we believe, my client believes, were made to prospective employers when he was in the process of trying to find alternative employment.
Did the employers tell him what was said to him?
You want to know what's in the record or what happened?
What does the complaint say that the prospective employers were told?
The complaint does not address the employment because we did not have that information.
What does the complaint say that DES was told?
What the complaint says
is defamatory.
That he was discharged for willful or negligent misconduct.
And I'm sorry, where is that in the complaint?
Paragraph 15. Paragraph 14 and 15, actually.
Well, I don't think it says exactly what you just said. Paragraph 14 says, defendant defamed and discredited Chris before DES by falsely representing the circumstances and characterization of his termination.
And then the administrative law judge specifically found those representations to be false and concluded that he was not discharged for willful or negligent misconduct. So I agree with you. If you want to say that the complaint is not a model of clarity, I agree with you on that point. But I think we should have had the opportunity to amend it to make those clarifications. I also think that under the rules related to interpretation in the context of motion to dismiss, where reasonable inferences are drawn from all of the factual allegations, it's a reasonable inference to say that those sorts of statements were made based on what we have pled.
Then we've got the whole privilege issue, and I really wasn't very persuaded by the reply brief's attempt to say why DES wasn't a forum where the privilege could be asserted.
Well, I think there are two reasons that the litigation privilege doesn't apply here so as to eliminate the defamation clause defense, the defamation claim. First is what happened, the context for the events that we are challenging with respect to DES is the review of an unemployment claim. No actual litigation. In fact, the defendant refused. To the extent there was a hearing, the defendant simply didn't show up. The other reason I don't think the litigation privilege can be applied in this context is normally in the litigation context you have a couple of safeguards, if you will, protecting the adversary from any sort of statement that may be made.
Let me just interrupt you. Is there any authority that says DES unemployment proceedings don't trigger the privilege? I mean, you give some policy reasons why you don't think it should, but I don't see any legal authority for that proposition. Are you aware of any?
I haven't seen any that supports the defendant's position. I haven't seen any that supports ours. But I would say that in the normal litigation process, you have Rule 11, which limits what an attorney and a party can say. You also have, if there's testimony, because the litigation privilege will also apply in the case of testimony, you have somebody being placed under oath, which provides a further safeguard. And I think those things, where they're not present, the litigation privilege simply shouldn't apply. I mean, that's our argument.
Can you jump to the intentional infliction claim?
Sure.
And can you give me, in a nutshell, and I know you're running out of time, but can you give me just in a nutshell the outrageous conduct that rises to the level that the case law has established as being necessary for an IIED claim? Something so outrageous that civilized society can't allow it.
Well, I think we need to keep in mind what the standard is, whether reasonable minds could differ as to whether the conduct is outrageous, intolerable, extreme, et cetera. With that said, I think we have an employer who was under the table hiring undocumented workers, in many cases not paying them. We have an employee who reported that, who tried to do the right thing, who said, I'm not gonna stand by and see this happen. And as a result, his very livelihood was taken away from him. I think that is extreme and outrageous. I also think that if you look at the Mintz case, I think a careful analysis of that case is actually pretty telling because there were a couple of things that actually saved the employer in that case, and those things are not present here. The two things that saved the employer in the Mintz case were, one, a failure to promote is never outrageous and extreme in the court's mind, and two, the employer's conduct, no matter how extreme, no matter how egregious, cannot be the basis for an intentional infliction claim if the employer had a legitimate business reason for its actions. And that's all found on page 554 of the Arizona report. I see that I've only got about 2 minutes left, so I'm happy to answer any additional questions you have. Otherwise, I'll try to reserve those 2 minutes.
Thank you.
Good morning. May it please the court. My name is Veronica Manolio, and I represent La Canasta, or the appellee in this matter. First of all, I think that the court has a very good grasp on the two issues that are key here, and that is, what is the prejudice and what is the futility if amendment were allowed? Those are the issues that we should be focused on, because Judge Gamma got it right.
Well, his ruling on the wrongful termination is a little enigmatic, is it not? Doesn't he say that the claim fails because there's no showing of discrimination?
He does, but I think that he it may be technical in nature because he says there's no showing of discrimination. Regardless of how he words it, he got it right for a couple of reasons. Number one, whether it was discrimination or, as Anzuris tries to differentiate it, retaliation, he missed the boat, Anzuris missed the boat because he didn't file timely. We can't miss that part. He missed the statute of limitations. No matter how he amended it, he chose, rather than to file a straight statutory claim, he chose to file with administrative agencies, both federal and state. He got right to sue letters, and he sat on them. He let the statute of limitations expire.
But that matters, I think, only as to count 4, discrimination, and not so much as to count 3, wrongful termination, which is based on the statute that Mr. Erickson discussed in his argument, that has a 1-year statute of limitations.
Except when you proceed with filing administratively. You can't ignore the right to sue letter when you've chosen to file the wrongful termination after having gone the administrative route.
Certainly for the federal claims or for a discrimination-based claim arising from them, but what's the authority that a state claim under 23-1501, which was what is alleged in count 3, is cut off by that same provision?
Because you can't separate the two. He's claiming that wrongful termination for retaliation out of the same facts, the same set of circumstances as he filed the retaliation claim under the federal and the state accompaniment for discrimination. He wants to pretend that there are 2 separate claims, the discrimination and the wrongful termination, and they really aren't. If he hadn't filed the discrimination claim and had just come straight to the court filing the wrongful termination for retaliation, he would have had a 1-year statute of limitations. Because he filed under the administrative remedy, he should have met the statute of limitations for the federal claim and the state claim with the state statute of limitations he was given under the right to sue letters. He tried to avoid his time limitation by doing so. There is no distinction between the retaliation claim and the discrimination claim, though he tries to make one. The difference is, however, it doesn't matter. His retaliation claim does not make a claim on its face, and here's why it's futile. The judge didn't need to specify anything further. He resigned. There was no retaliation. The judge said it was futile, and he created the prejudice to himself.
But that's a disputed question of fact, whether he resigned or was fired.
Agreed. Why did he create the issue? He said, Judge, I need leave to amend. He didn't give a proposed amendment, which he should have done under Rule 15. He didn't say, here's what it would look like, Judge. When he replied, he didn't say, we responded and said, give us a more definite statement. We filed a motion to dismiss or a more definite statement. He didn't say, here's my response and an amended complaint. Here's how I would fix it, Judge. Here's the cure.
Counsel says he couldn't do that because he didn't get the discovery that he requested. How do you respond to that?
He didn't need discovery to file the wrongful discharge claim. He never said that. He said he needed discovery to file the breach of contract claim because he didn't know if there was a contract. Well, first of all, you don't file under Rule 11. You don't file a breach of contract claim if you don't know if there's a contract. That's not on appeal anyway, so I don't know why it was brought up. But he's never told you he didn't have the right discovery on the retaliation claim because he had to have that. What he said is, maybe I should have beefed up my allegations. Well, you had multiple choices, or multiple times to do it. You didn't do it when you said, I want leave to amend. You didn't do it in reply to our motion, in response to our motion to dismiss. You didn't do it on your motion for a new trial. Say, I want a new trial. And by the way, Judge, here's my proposed first amended complaint. If you would just grant a new trial, this is what I would file. He never, after 3 missed opportunities, said this is what the first amended complaint would look like. He had every opportunity to tell the judge it wouldn't be futile, and here's why. He didn't even do that for this court. In fact, today he says we could go beef up our allegations. And that's only on the retaliation charge. He has not and cannot beef it up, or he should have done that. We're fighting over whether or not he should have done something, and he's never proposed to this court or to Judge Gamma what that beefed up complaint would look like. Why?
Why wasn't it good enough in the first place?
Because
when he alleged that his employment was terminated for, quote, refusing to condone facilitate or turn a blind eye to unlawful activities, unquote. Why isn't that good enough?
The reason it's not good enough, and we put it in our motion to dismiss, and I find it odd that Mr. Anzuris didn't attach his letter where he says, I reported violations and offered to have them fix it, and they retaliated by firing me. Because the first line of his letter is, I'm resigning. I find it odd he didn't put that letter in his complaint and say, see, here's why. Because, Judge, you asked the question earlier about wagon seller.
Allegation, I mean, he doesn't have to prove it.
Of course he doesn't have to prove it, because he did resign. He did not give a letter. The question you asked earlier about wagon seller, this is a statutory claim. His statutory claim is under 12-1501, which says, I'm putting you, the employer, on notice that there's bad conditions and I want them fixed. That's not what he did in this case. He said, I'm resigning.
But he said he said that's what he did.
You can put anything you want on paper. I can say you defamed me right now, and then I can pretend I need discovery to prove it.
A prospective failure of proof, but
right.
Didn't he allege enough to allege a retaliatory termination?
He did. And then when we file a motion to dismiss and we say, because the allegations are this, and we attach the federal and the state complaints of discrimination, and we footnote and say, this isn't outside the pleadings because it goes to the heart of the allegations, and Judge Gammer reads it and says, wow, the complaint is not commensurate with what he said to either the EEOC or the Attorney General's office. I can read the allegations of the complaint against what he said to the EEOC and the Arizona Attorney General, and I can say this is not commensurate and this is futile, and I can say this can't be cured on
not the same as saying, well, he says something one thing in the complaint, and then your answer says, well, previously he had said something different. Doesn't that just present a proof question?
Absolutely not. That's a judge doing exactly what he's supposed to do, which says this is a frivolous claim that shouldn't be in the system, and I, at this level, am allowed to say this is something that can't be cured by defect, and rather than waste the judicial system, to say you can amend 1,000 times, but if you can't state a claim for relief, I don't need to let this case go through my court system. And do I wish that Judge Gama had fleshed it out more? Yes. But as Judge Downey pointed out earlier, there's no need to turn something over on a technical defect in the minute entry when the result should be the same. And I don't want to just touch on the retaliation claim, because the same remains for the other two. On defamation, there was no discovery that needed to be had to find out the complaint fails. He says, well, prospective employers might have said something bad. He doesn't have a single allegation of a known prospective employer that La Canasta even talked to, much less something that...
Today he seems to be relying on an assertion that La Canasta falsely asserted that Anzuris was terminated for misconduct.
That's the DES, and I'm getting there, and I'll gladly go there right this minute. DES,
I raised it because the only thing I recall from the complaint was this assertion that La Canasta falsely represented the circumstances and characterization of his termination to the DES.
He also said, and possibly prospective employers, not with having anyone named, but he said DES as well. And the litigation privilege absolutely applies. If you look at our response brief, we cited it, and you look at the Green Acres case, it absolutely says in the context of employers that any function of the state government, including administrative functions, I think we all agree that the Arizona Department of Economic Security is a state government agency. When an employer is defending itself in an administrative proceeding before DES, they are protected by the privilege. They are allowed to defend themselves, and they are allowed to give statements that we thought his conduct was negligent on the job. That is a protected statement. They didn't publish it to third parties. It didn't go out to the public. And there's no allegation of harm. He'd already lost his job. He can't say that he lost his job because they gave their side of the story to DES. There could be no harm that would arise from that, nor was it pled in the complaint that that caused a harm. His job was already gone. So what's the damage? What La Canasta reported to DES is not and could not be on amendment any cause of damage. So then all you have is this amorphous, well, potentially third-party employers, but there's not one. They just made a blanket allegation. Like I said earlier, I could go out and write a complaint today and say, well, the Court of Appeals defamed me because they didn't agree with me. That's not a valid complaint. I don't get to get discovery into your computers to see if you possibly wrote emails about me to someone. And that's what they're trying to do. They're trying to say, well, we get discovery into your communications to see if you potentially talked badly about me. They don't have any reason to believe that La Canasta said anything about Mr. Anzoris after he left employment. They have no allegation that he did it other than a blanket statement that he potentially could have.
I hate to go backwards, but I think in my view, your weakest point on appeal is the wrongful termination retaliation claim. And let me explore a little bit more something you said that I'm not finding support for legally. And that's the notion that following the federal procedure somehow then foreclosed his Arizona statutory claim. And if you look at the right to sue letter, it gives a recipient 90 days to sue for Title VII violations, ADA violations, and other federal claims. I'm not finding any authority for the proposition that by going that route, he thereby waived his right to bring an action independently based on an Arizona statute, which I think count 4 of the complaint. No, that count 4 was the discrimination, and he's not even trying to revive that one on appeal. Count 3. So what authority is there for the proposition that going through the EEOC process then cut off his ability to sue under the Arizona statute?
Here's my position on that when he filed his charge of discrimination through the AG's office, he filed saying that he was discriminated against and that he was asked to violate statutes of the state of Arizona. The charges for discrimination go hand in hand with his charges for violation under 23-1501.
Well, the facts and allegations may be the same, but the causes of action are entirely different. And it's not as if he can't ever rely on those facts for any purpose because they were part of the EEOC proceeding if he has an independent, separate claim based on them.
I don't disagree with you, but what I do say, Your Honor, is that he relied on the same facts and circumstances when he filed with EEOC and the AG's office and said, I was asked to do things that I wasn't supposed to do, and he put the state on notice and said, I was told to do these things, and they were violations of the statutes of this state and federal law. And they say, we don't see that, but here, you get 90 days, go sue.
For federal claims and under federal acts, and so he presumably would be time barred on those. But I don't equate that, and I think there's a missing link in saying that then forecloses his state statutorily based claim.
Okay, and I agree with you that even if this court and or Judge Gamma say the discrimination claims are time barred, but the APEA claims are not time barred, he's timely under 23-1501. Even if you get past that hurdle and say it's not a time limitation, you still then have the hurdle of how do you get around that statutorily when he did not get terminated in retaliation?
No, I understand.
You still then have the futility argument. But I understand what you're saying when you say I only agree on the federal part. I don't agree that on the state claims he loses his timeliness.
Well, effectively, the federal claim does not preempt the state claim.
Yes. And I don't agree with it, but I understand if that's how you make the distinction. And I agree that that's their best argument. But I still don't think that he stated a claim that's valid because at least we know that in the Arizona Attorney General's office, they didn't find that he had established a claim valid enough to go forward. And they said, go sue.
But again, that's weighing the evidence. This is 12b-6. It's not looking strictly at the allegation of the complaint. And so I'm having a problem with that prong.
Totally understand. I think that Judge Gamma did look at the claims and looked at the 2 charges and the dismissals. And the one thing I do want to note is that it's not just a state claim. It's not just a federal claim. Remember, he files 2 separate ones. There's the Arizona Attorney General and the EEOC. So they're done both state and federally, even though I understand you're saying it's typically when they give the right to sue, they say suing under federal law. But the AG's office and the EEOC both look at them, and that's what Judge Gamma looked at because we attached them both and said they're not outside the pleadings because he's relying on them in his allegations of the complaint. And that's why we believe that Judge Gamma said, we don't see that there's any way you can amend around this. And again, we think that the plaintiff, or Mr. Enzeris, created his own prejudice by not amending and telling Judge Gamma, no, Judge, we can get around it. Here's how we will amend. Here's how we will cure our defect. I know you said you think that's the claim that's the weakest on our side, but I do want to touch the last claim, which we haven't addressed, is the IIED claim. There's not a single allegation in the complaint, nor could there be, that anything was aimed at Mr. Enzeris individually. To even make an intentional infliction claim, you have to allege that something was intended for you personally or done with such a reckless disregard that it was aimed at you. He doesn't even allege that La Canasta did anything that was specifically aimed to make Mr. Enzeris feel the infliction of pain. He doesn't ever claim what his severe emotional distress is. He says, I have damages. That's the most blanket allegation that comes in every complaint. You had a duty, you breached it, and you caused me damages. That's a blanket allegation that's in every tort complaint. There's nothing that he alleges that's extreme or outrageous. There's nothing that any case says is, so outrageous in our society, and there's nothing at all that talks about the requisite intent aimed at him. There's just no doubt that that claim was not pled, and again, if it could have been amended, it should have been. So I think that at best, there was a technical defect by Judge Gamma, but I think that for all the reasons cited in the record and the response brief, that this court should uphold the dismissal. There's no reason to bog the trial court down with letting them refile this lawsuit. So unless this court has any questions, I'm done. Thank you.
Brief rebuttal, Mr. Erickson.
I will do my best to make 3 short points in 1 minute and 46 seconds. First of all, I'm not conceding that the documents that were attached to the motion to dismiss are appropriate in the context of a motion to dismiss, but the court is right to focus on the charge of discrimination with the Arizona Attorney General's office, because what Mr. Enzeris alleged was a hostile work environment, and then there was a religious component to that because some people had come in and blessed the workspace. There was no requirement that he plead every claim or make every claim he thought he might have to the AG, and there's no authority that suggests that he's barred by failing to do so. And of course, my understanding is this was in fact referred to the EEOC. That's how this got started. And the EEOC dismissal and notice of rights, as Judge Downey has already pointed out, it is fairly clear. I mean, it specifically says no finding is made as to any other issues that might be construed as having been raised by this charge. The right to sue is under federal law only, that it may be time barred after 90 days. And that's very clear. In fact, it says the time limit for filing suit based on a claim under state law may be different, and in fact it is. So I think the court is well acquainted with the problems with the argument that the wrongful termination claim is barred for that reason. And Judge Thompson, I think, sort of keyed in on the trial judge's ruling with respect to wrongful termination retaliation. That's on page 3 of the minute entry. And it's very clear from reading that minute entry that all Judge Gamma was focused on was whether the plaintiff was able to plead discrimination, whether he had factual basis. And of course, we actually didn't know whether somebody younger or of a different gender was hired because we weren't allowed discovery, but we couldn't plead it. And because we couldn't plead that aspect of discrimination, Judge Gamma rejected the wrongful termination retaliation claim. And I think if you study that one paragraph, that tells you pretty much all you need to know. And the final thing I would say,
Briefly.
just with respect to the amendment issue, because I think it would be helpful to the practitioners, because I will tell the court that as a matter of standard practice, when facing a motion to dismiss, often you don't draft up a separate motion to amend. You request leave to amend in the context of responding to the motion to dismiss. And if the rules require one to actually propose an amended complaint in compliance with Rule 15, I think it would be very helpful for this court to say so.
Thank you. Thank you both for your presentations. We will take this matter under advisement and issue a ruling in due course. At this time, we will stand in recess in preparation for our next argument. Thank you.